Firstly, the element in law of negligence is duty of care owed by the defendant to the plaintiff. A person will only be liable in negligence if he is under a legal duty of care. Hence, not every careless act done by a person results in him being held responsible in law. He will only be liable in negligence if he is under a legal duty to take care. The duty must arise out of some relation or some proximity between the parties, driver and road user, manufacturer and consumer, also the builder and the buyer. The duty of care may arise in contract, in tort, or may be owned by a professional to a client or to a third party. A defendant must owe duty of care to the plaintiff. Thus, duty of care is defined as an obligation recognized by law to avoid conduct fraud with unreasonable risk to dangers to others.
From the first element, the primary test or principle has been applied to determine the existence of a duty of care is the famous neighbor principle. This principle was laid down in the landmark case of Donahue vs. Stevenson's 1932. The case is began where the defendant, a ginger beer manufacturer, had sold ginger beer to a retailer. The ginger beer bottles were opaque. A bought a bottle and entertained her friend, the plaintiff, who drank the ginger beer. When A refilled the glass, along with the ginger beer came out the decomposed remains of a snail. The plaintiff suffered shock and was severely ill as a consequence. The plaintiff sued the manufacturer and claimed that the manufacturer had a duty in the course of his business to prevent snails from entering his ginger beer bottles. The court held although there was no contractual duty on the part of the manufacturer towards A friend, the manufacturer owed her duty to take care that the bottle did not contain noxious matter, and he would be liable if that duty were broken. Thus, the defendant is liable.
Second element for negligence are breach of duty of care by the defendant. Once it is established that the defendant owes the plaintiff a duty of care, the next step is to consider whether the defendant has breached that duty. The test for deciding whether there has been a breach of duty is laid down in the dictum of Alderson B. Imbliff and the Company of Operators of the Birmingham Waterworks 1856. Negligence is the omission to do something which a reasonable man would do or doing something which a prudent and reasonable man would not do. A reasonable man has been described as the man on the omnibus. In other words, it means an ordinary man who is not expected to have any particular skill, such as that possessed by a surgeon, a lawyer, or a plumber, unless he is actually one. It is for the judge to decide what, in the circumstances of the particular case, the reasonable man would have in contemplation and what is ought to have been foreseen.
In the second element, we can insert a case of Hilda vs. Associated Portland Cement Manufacturer Limited. The case is begin with the plaintiff's husband was riding his motorcycle along a road outside a piece of open land, occupied by the defendants and where children were permitted to play football. A ball was kicked into the road, causing the plaintiff's husband to have an accident. The court held that, in view of the likelihood of injury to passers-by, the defendants are liable for having permitted football to be played on their land without having taken any additional precautions.
Lastly, the third element are consequential damage to the plaintiff. The third element of negligence which must be proved by the plaintiff is damage or injury must have been caused by the defendant's breach of duty. Plaintiff damage must not be too remote a consequence of it. This means that one has to ask whether the breach of duty was the primary cause of the damage. The question that arises whether the defendant's conduct has in fact caused the plaintiff damage. Did the defendant's breach of duty in fact cause damage suffered by the plaintiff? The question for the defendant's breach of duty, would the plaintiff have suffered any injury or damage? If the answer is yes, then the defendant's breach did not cause the plaintiff injury.
This can be relating to the case of the wagon mount. Overseas Steamship Limited were characterized by demise of the wagon norm. An oil-burning vessel, which was moored at the Crude Oil Company wharf in Sydney Harbour for the purpose of taking on fuel oil. Due to the carelessness of Overseas Steamship Limited servants, a large quantity of fuel oil was spilled onto the water, and after a few hours, this had spread to Mort Dock Limited wharf about 600 feet away, where another ship, the Corrimal, was under repair. Welding was being carried out on the Corrimal, but when Mort Dock Limited manager became aware of the presence of the oil, he stopped the welding operations and inquired from crude oil components whether they could safely continue welding. The court found as a fact that it was unforeseeable that fuel oil sprayed on water would catch fire, and some foreseeable damage from the oil spill was caused to Mok Dock Limited wharf in that oil had got onto the shipways and interfered with their use.
Application of law. In a previous situation, the ad of the trainee beauty therapist from Magic Beauty Salon named Miss Lim resulted in her patient condition, which is EFA, the veteran actress, getting worse the effects of doing Botox treatment by looking at the first element, which is duty of care. From the case of EFA versus Magic Beauty Salon, we can see that Magic Salon owes EFA a duty of care because they have a strong relationship, whereas cosmeticians and consumers, the neighborhood principle exists, where the close relationship between the plaintiff and defendants creates a duty of care. The case is comparable to the Donoghue versus Stevenson case, where the relationship is between Donoghue and the restaurant, because the nearest party that can be blamed was the restaurant, not the manufacturer or the retailer, and that is why the neighborhood principle exists in this case. Thus, the first element is fulfilled.
For the next element, it can be seen that Magic Beauty Salon has breach of duty of care by not reminded EFA whether she is allergic to Botox, even though Miss Lim's instructor had always reminded her to ask patients that important question. As a reasonable man, Magic Beauty Salon have to make sure that before doing the Botox treatment, they have to ask the patients, which is EFA, whether they are allergic to Botox or not, because it will give a side effect to the patient that have a problem of Botox treatment. This can be seen in the case of Little V Associated Portland Cement Manufacturers, where the defendants give a permission to the children to play football without having taken any additional precautions. Thus, the second element fulfilled. Lastly, the element in negligence is damages. EFA, the veteran actress, suffered rashes on her face, and instead of making her look younger. Other than that, the treatment had made her look older because the allergic reaction made her face wrinkle even more. Magic Beauty Salons should be able to foresee that if they do not ask their customers whether they are allergic to Botox, because if yes, it will injure or hurt them. Thus, the last element also fulfilled.
Conclusion. To sum up, all elements in law of negligence are proven. Thus, EFA can take legal action against Magic Beauty Salon for the injury that have inflicted. However, Magic Beauty Salon can use self-defense to defend themselves. It can be said that if EFA tell them early that she had allergic to Botox treatment, this all would not be happen.